Good evening. Will the Standing Committee on Justice please come to order? Before the committee can proceed with the business before it, it must elect a chairperson. Are there any nominations? Minister Sandhu?
Should I say MLA or MLA Logan Exenham?
No, as a chair, Pancratz. Yeah.
MLA from Waverly, please.
MLA for Waverly.
MLA Pancratz has been nominated. Are there any other nominations? Hearing no other nominations, MLA Pancratz, will you please take the chair?
Our next item of business is the election of a vice chairperson. Are there any nominations? Yes, Minister Weeb.
Yeah, I would like to nominate MLA Oxenham.
Emily Oxenham has been nominated. Are there any other nominations? Hearing no other nominations, Emily Oxenham is elected vice chairperson. This meeting has been called to consider the following bills. Bill number 2, the Provincial Court Amendment Act. Bill number 5, the Highway Traffic Amendment Act, Impaired Driving Measures. Bill number 31, the Property Controls for Grocery Stores and Supermarkets Act, various acts amended. And Bill number 42, the Buy Canadian Act, Government Purchases Act amended. I would like to inform all in attendance of the provisions in our rules regarding the hour of adjournment. A standing committee meeting to consider a bill must not sit past midnight to hear public presentations or to consider clause by clause of a bill, except by unanimous consent of the committee. Written submissions from the following persons have been received and distributed to committee members. Tanya Hanson-Pratt from MAD Canada on Bill 5. Does the committee agree to have these documents appear in the Hansard transcript of this meeting?
Agreed.
Agreed and so ordered. Prior to proceeding with public presentations, I would like to advise members of the public regarding the process for speaking in a committee. In accordance with our rules, a time limit of 10 minutes has been allotted for presentations, with another 5 minutes allowed for questions from committee members. Questions shall not exceed 45 seconds in length, with no time limit for answers. Questions may be addressed to presenters in the following rotation. First, the minister sponsoring the bill or another member of their caucus. Second, a member of the official opposition. And third, an independent member. If a presenter is not in attendance when their name is called, they will be dropped to the bottom of the list. If the presenter is not in attendance when their name is called a second time, they will be removed from the presenters list. The proceedings of our meetings are recorded in order to provide a verbatim transcript. Each time someone wishes to speak, whether it be an MLA or a presenter, I first have to say the person's name. This is the signal for the Hansard recorder to turn the mics on and off. On the topic of determining the order of public presentations, I will also note that we have out-of-town presenters in attendance, which are marked with an asterisk on the list. With these considerations in mind then, in what order does the committee wish to hear the presentations? Minister Weevil. Oh, yeah, Mr. Balkin.
I would suggest that we go by bill in order, considering presenters and ensuring out-of-town presenters are first and followed by in-person presenters.
Okay. Is that agreed? Thank you for your patience then. Agreed.
Sorry, repeat that back to the committee and then ask if they're agreed.
Okay, we will go in order of the bills through the numbers, and then we will go through presenters with our out-of-town presenters going first, followed by those who are in attendance here today. Is that agreed?
Agreed.
Agreed and so ordered. Thank you for your patience. We will now proceed with public presentations. So I will now call on Ms. Susan Dawes, Provincial Judges Association of Manitoba. Ms. Dawes, please proceed with your presentation.
Thank you. I'm counsel for the Provincial Judges Association of Manitoba.
My
known as-
apologies, I have to interrupt you quickly. Do you have any written materials to distribute to the committee? Okay, thank you. Please proceed. My apologies.
So I was saying I'm counsel for the Provincial Judges Association of Manitoba, known as PJAM. PJAM is a professional association for judges. It represents all 43 full-time judges, including the chief judge and the associate chief judges, as well as 14 senior judges. As the member from Brandon West predicted during the second reading of this bill, I'm indeed back to speak to it. In doing so, I want to be very clear that PJAM is in no way opposed to judicial education. In fact, PJAM vigorously supports the need for its members to have access to high-quality judicial education. And I will also say at the outset that PJAM members recognize the trauma and challenges that victims face, and they see and hear it in their work. In 2022, I spoke to this committee regarding Bill 8, which was brought in the first of what I'll call the judicial education amendments. At that time, we raised concerns about the intrusion on judicial independence and indicated that the legislation could be perceived as the legislative branch of government directing the judiciary in an area that's clearly a matter of judicial independence. That bill was passed, and as a result, Section 8.1.1, sub 1 of the Act provides that the Chief Judge may establish seminars related to sexual assault law and social context, which include systemic racism and systemic discrimination. The Chief Judge should establish seminars, should ensure that seminars are established after consultation with a list of suggested groups, and that the Chief Judge should include certain information in the court's annual report. And the permissive language is important, as it would be unconstitutional for the legislature to direct or mandate judicial education. In 2024, Bill 209 was introduced, and the bill would have added 2 topics: intimate partner violence and coercive control to the list of education topics. Also, it would have added to the list of persons with whom it was suggested that the Chief Judge should consult in establishing the seminars. I spoke to this committee in October of 2024 about Bill 209, voicing concerns about the interference with judicial independence, and I pointed out that the concern was heightened when there was no consultation with the court prior to the bill being introduced. And I made the point that any legislative influence over judicial education is troubling, as it brings with it a potential for harm to the public perception of judicial independence and impartiality and neutrality. That bill was withdrawn. Bill 41 was introduced, and as we all know, Bill 41 didn't make it to committee, and it's now been reintroduced as Bill 2. Bill 2 now lists 5 education topics, and we have a longer list of who it is suggested that the Chief Judge should consult with. One looks at this and thinks, who's next? What's next? PJAM considers that the inclusion of an expanding list of topics for judicial education is an incursion on judicial independence. But we must also ask, should public input into judicial education occur through amendments to legislation? Or would it be better for the branches of government to discuss these matters, to consult with one another, and to reach an understanding? PJAM considers that the latter would be a much better approach and one that would support judicial independence. I would note that at the federal level, a memorandum of understanding was reached between the Canadian Judicial Council and the Minister of Justice and Attorney General for Canada concerning judicial education. And that document sets out mutual commitments to the importance of judicial education, including social context education, and defines certain roles and responsibilities for the different branches of government. PJAM would support a similar approach here, and that would ensure the opportunity for consultation, but it would also clarify that it is the court and only the court that must manage judicial education as a matter of judicial independence. PJAM is also concerned about the impact of the discussion around these bills on the reputation of the court and the administration of justice more generally. Both in and outside of the legislature, proponents of Bills 209 and 41 emphasize the urgency of passing the bills. Their comments implied that the public is somehow unsafe in the Provincial Court of Manitoba in the absence of this education. That implicit assertion is tremendously troubling to the judiciary, who work tirelessly and incredibly hard delivering a very high quality of justice in this province every day. As we've pointed out in the past, the judiciary already receives education in the areas identified, whether through seminars put on by the court itself or through the high-quality judicial education offered by organizations such as the National Judicial Institute. Notably, not one of the case law examples that were cited in support or as support for the need for this education originated in the Provincial Court of Manitoba. Not a single one. Even if they had, there is already a robust judicial council process to address such a situation. The stated implication, or the implication of the stated urgency in passing the bills, is damaging to the reputation of the court in the eyes of the public and ultimately serves to reduce the confidence in the administration of justice. We don't expect that this is the government's intention. Finally, I want to address resources for judicial education. The minister emphasized in his remarks at the second reading that Bill 2 improved upon Bill 209 because it added funding. He explained that there have been years in the past in which funding has lapsed, in that the court was not permitted to carry over unused funds into the next fiscal year. Let's be clear, the court's education budget has been frozen at $40,000 since 2005. If that amount was adjusted for inflation, it would be well over $61,000 by now. But it remains frozen, and there's been no added funding for the court's education budget. None is provided in this bill. It's true that funds from that budget did lapse in past years. To my understanding, this happened during COVID years when the court could not hold in-person education sessions that the court arranges with this budget. In ordinary years, though, the funding is woefully insufficient. The pressure on that funding will be compounded by the addition of new topics, not to mention that there are new developments each and every day in every aspect of criminal law. If this legislature wishes to support judicial education, it needs to restore the amount of this education budget to an appropriate level and ensure increases on the go forward to account for inflation. Finally, time spent on judicial education means judges are not in a courtroom. That means fewer cases heard. Consideration must be given to ensuring an adequate number of judges to ensure that judicial education does not impact the court's ability to provide for timely administration of justice. On behalf of PJAM, I want to thank the committee for listening to these concerns, and if you have questions, I'd be pleased to try to answer them.
Thank you for the presentation, Ms. Dawes. Do members of the committee have questions for the presenter? Minister Wiebe.
Well, I just wanted to offer my thanks, Ms. Dawes, for coming to committee once again. A special thanks to the judges who, of course, Chief Judge and others that we've been working very closely with on this legislation to ensure that we're both respecting the judicial independence, as you mentioned, is so vital and so fundamental to what we do, but also finding that, as you said, the last 5 years, money lapsed, now going to be rolled over. Simply a thank you for the work, and I know that there's more work to be done. You mentioned the MOU and others, so very happy to work with you and continue to make sure that we're supporting the important work of the judiciary throughout the province. Thank you.
Mr. Balkin.
Well, thank you again for presenting to the committee and really reinforcing the fact that we don't want to trample on judicial independence, and we certainly want to make sure that the impartiality and neutrality of our courts are taken into consideration. What would be your suggestion, rather than this bill, what could we do differently if this bill was, say, removed tonight? What would be your suggestion?
Ms. Dawes.
Rather than this bill, I think consultation between the parties and a memorandum of understanding outlining the respective roles of the branches of government with provisions for adequate and appropriate funding for judicial education would be an appropriate way to move forward.
Ms. Lamoureux.
Thank you, Mr. Chairperson. Thank you for your presentation tonight and again previously back in the fall. You bring an incredibly important perspective to the committee, and you're right, it is something that all MLAs, members of parliament, every level of government should be working within the rule of law to ensure that the judiciary is kept separate from politics. I do think that this legislation is very important, whether it's the former bills, the newer bill coming up. Is there something that, when you talk about the appropriate level of funding, that could be done or added, whether it's through this legislation or a new piece, that would help the judiciary maybe feel better about it?
Well, I think...
Sorry, Ms. Dawes, I just need to acknowledge you. Yeah. Ms. Dawes, please.
Thank you for the question. I think those issues are best addressed through the chief judge, who can speak for the court. Certainly, the court is very passionate about judicial education, as I've said, and has long been undertaking many of these topics already. I think the discussion about securing adequate funding, ensuring that that's in place to promote these initiatives is certainly something that would assist. But at the end of the day, the court has to control judicial education. There's just no ifs, ands, and buts about it. And so we appreciate the permissive language, but the inclusion of more and more topics makes it look more and more like a direction to the court, which ultimately is inappropriate and a violation or incursion on judicial independence.
Thank you, Ms. Dawes. Are there any further questions? Yeah, Mr. Balkin.
Yes, just wondering, the consultation that was held, you were clear at the last committee meeting in 2024 that there was a lack of consultation. There needed to be consultation with the courts. So I'm just wondering, I'm assuming that government consulted with the chief judge and with PJAM, and I'm just wondering what recommendations came from that consultation.
I'm not in a position
Ms. Dawes.
Thank you, Mr. Chairperson. I apologize. I'm not in a position to get into the consultations as I wasn't part of them personally. I think the minister would be best to speak to those, but I do understand there have been some discussions more recently after introduction of the bill, and that those have been a very positive step from the perspective of PJAM.
Any further questions? Mr. Balkin.
With the financial costs for judicial education, I'm wondering if you would comment on an amount that you would think would be appropriate with the ever cascading number of educational seminars that this government bill is putting on to PJAM.
Ms. Dawes.
Thank you. As I said, the current education budget was established in 2005 at $40,000, and inflation adjusted, it would be over $61,000 roughly to provide what was provided then. That does not take into account these new initiatives and all of that, and I think the chief judge and the court can better speak to their needs. I would emphasize as well that judges also receive an individual education allowance that is allotted through the Judicial Compensation Committee process. That amount is woefully inadequate as well. And we all know that the costs of whether it's conference fees, whether it's travel, whether it's hotels when they're attending high quality education put on by the Canadian Association of Provincial Court Judges or the National Judicial Institute, the costs are ever rising. ever increasing, and we need to support the judiciary in obtaining that education. It's in the public interest, it's to our mutual benefit, and I expect you may well hear more about that in the context of the next Judicial Compensation Committee process, never mind this education budget itself.
Thank you, Ms. Dawes. And that concludes questions for this presenter. I will now call on Mr. David Grant to present. Mr. Grant, do you have any written materials for the committee today?
Just some kind words.
Okay. Well, please proceed with your presentation, Mr.
Okay,
Grant.
thank you. I'm once again in support of this bill. I think I spoke last time something similar was here a year ago. And I will, without getting into how much should be paid and which courses a person goes on, I think were sound reasons presented by the government for aiming the educational direction that the government wants. And I think those reasons still exist. And I think while I was part of a different organization of professionals, self-regulating, I learned that what was set up decades or a century ago with noble intent and by the smartest people in the day, it's fairly clear that either there were weaknesses in the initial plan or people have ignored the rules too much. And so I would support the bill mainly for that reason, and also offer my comments when I've been involved with the judicial system. Usually doesn't involve handcuffs, but just observing from the cheap seats, and then writing to chief judges or whoever. I've found that the mechanisms for correcting pretty blatant errors on the part of judicial staff, the mechanisms for correcting that are pretty much useless. That if you write a learned explanation of why this is what seems to be a mistake, here's what could have been done to prevent it, and the system tends to never take them seriously. I would say over 30, 35 years that I've been writing, I've had one minister take it seriously, but nothing happened. And beyond that, the staff tend not to take any action other than to assure me that all is well. So I would, again, I can see the point of view of the professionals. They want to be controlling their own ship. But I would say that ship operates in very flawed ways, and that you should pursue this to the extent that you can, and perhaps even get involved with other areas that come to the minister's attention where there's weakness in the system, where mistakes are made and they aren't self-correcting. Because in general, in professions, if there's a chronic mistake made over and over, the system should notice and the system should fix itself. And I would say in this case, the mechanisms and incentives don't seem to be there to make those corrections. And I would applaud the minister for making a tiny step in the right direction. So, thank you.
Thank you for your presentation, Mr. Grant. Do members of the committee have questions for the presenter? Minister Wiebe.
I wanted to thank you once again, Mr. Grant, for coming to committee, and really kudos to a member for Tyndall Park who's brought the bill in the past and now has brought it back. I think your participation, while maybe you don't always feel that it's, it does make a difference. It's not always you feel that your specific demands are being adhered to, but I do think that there is a value to this as a citizen that you've decided to participate here. So I just wanted to thank you, and thank you for the participation and your input on this.
Mr. Grant. Yeah. Thank you, Mr. Grant. Are there any other questions? Yeah, Mr. Balkin.
And again, a comment, thank you very much, Mr. Grant. Been involved in this committee process now for the past year and a half. I note that you're at many of the committees to bring the public's opinion forward. So I thank you very much. And I know you were at MLA Lamoureux's committee on Bill 209, I believe it was, and really was the springboard for this. So I thank you for your words at that time as well.
Are there any further questions? Ms. Lamoureux?
Thank you, Mr. Chairperson, and thank you, Mr. Grant, as well, for coming to committee tonight and to previous committees as well, and voicing your opinion and sharing your experience and expertise on the topic as well. Just wanted to be able to echo my colleagues' thoughts, and thank you for that.
Are there any further questions? If there are no further questions, thank you so much, Mr. Grant, for being here with us today. I will now call on Mr. Corey Hose to present. Fine. Do you have any written materials for the committee today? Thank you very much. Please proceed with your presentation.
As I understood it, today's amendment to Bill 2 about the Provincial Court Amendment Act, there was discussions on training our judges, providing more training to our judges in coercive control, potentially parental alienation, false allegations, and weaponizing of the legal system to one's advantage in a divorce or separation. I'm here on behalf of a lot of confused parents and a lot of hurt and confused children. 10 minutes isn't quite enough, and so I'm not going to be able to get through everything, so you have everything in your hands. I'm going to read the first 8 pages. Is that okay with you? There's an epidemic going on in Winnipeg right now, and none of the public, most of the public has not heard of it. Only police, the domestic violence unit, the family and criminal court have heard about this epidemic that's going on. Did you know that under the new Manitoba family law reforms, you can steal full custody of your children in your divorce by baiting your spouse into 2 very specific arrests? Did you know that our police and judges are openly stating that lawyers are weaponizing these loopholes and are guiding their clients to falsely bait their partners into these 2 specific arrests in order to increase their legal fees in the custody battle that comes of it? Recently, our MPs and local Manitoba MLAs have been discussing the current state of our family law system. Under scrutiny are 2 new terms called coercive control and parental alienation. Many angry groups nationwide are at odds with each other and are each trying to push their ideologies to reform the family law system. Our groups of men, women, and grandparents have no concerns if those reforms are meant to protect people. We do, however, have concerns given that those reforms are now being weaponized by lawyers to hurt people. What I'm about to tell you I've never heard of before. In the last 6 months, I've interviewed both men and women who were baited into an arrest, almost all of whom have lost all contact with their children as a result. Police, the domestic violence unit, and our court judges have said this has now become an epidemic in Winnipeg, and that this epidemic is being guided entirely by lawyers. The Manitoba taxpayer will spend millions of dollars per divorce file needlessly when these divorce tactics trigger incredible police presence, the domestic violence unit, child and family services, the Crown prosecutor, and tie up the criminal and family courts. Baiting arrests falls under the definitions of domestic violence, coercive control, parental alienation, and child abuse, and it is recommended it be considered a criminal offense. Manitoba's new family law reforms state that if 5 tests of domestic violence are passed in a separation, that one party will receive full custody of the children. 2 of the most important and heavily weighted tests of domestic violence include an arrest for domestic violence and an arrest for breaching a protection order. These reforms that were first meant to protect the public are now being weaponized against them. Discussions with the Winnipeg police see that those looking to monetize their children in divorce use these 2 reforms to their advantage. An arrest for domestic violence and an arrest for breaching a protection order are now becoming a daily occurrence, says the Winnipeg police. The problem our group of parents and grandparents have is that this lawyer's game is stealing children from their families and are causing excessive rates of sadness, depression, self-harm, bankruptcy, and attempted suicides in both parents and children. Legal fees for the average divorce cost approximately $5,000. Legal fees on these lawyer-guided messy divorces are reaching $300,000 per couple. Therefore, guiding these tactics are very lucrative for a lawyer if they can sell their client on using them. In Canada, we are experiencing a nationwide housing crisis. And so, in order to share the home and its contents equally amongst the parties and keep the children in the family home while divorce proceedings are underway, a law was created to maintain normalcy for everyone. Manitoba family law states that each party is entitled to equal enjoyment of the family home during separation. The divorce court is designed in such a way that it prolongs a simple breakup between two people and drags a divorce on for between 2 and 4 years in duration or longer. Being without a home half-time for 2 to 4 years would be destructive to anyone. And so laws were put in place to protect people, including the children, so to not throw a man or woman and their kids out onto the street during a nationwide housing crisis. The family home and its contents is typically the family's most valuable asset to be divided. In a coercively controlling divorce, having the home and its contents to yourself becomes very important. And as such, a loophole is being used to circumvent Manitoba law and give the home and its contents to one party exclusively. Seizing control of the family home and its possessions, the family's most valuable asset, is now accomplished with a protection order. The courthouse at 408 York Avenue has been so inundated with people abusing protection order applications in their divorces that they are crying foul and denying almost every protection order application that comes through their office. I spoke to the Manitoba Association of Women's Shelters and the Fort Garry Women's Resource Centre, and they say they are having an incredibly difficult time getting a protection order for the women who need help. This inundation of people abusing the protection order to gain the lion's share in divorce is denying a protection order to those who actually need one. Real victims are being harmed by those who falsely abuse our legal system. The media, our MLAs, MPs, and ministers are all discussing how intimate partner and domestic violence rates are increasing in our province. Yet, a protection order is being denied at the court office every single time when someone requests protection. As lawmakers, you must understand that that doesn't make any sense. Perhaps we should tell that to our missing and murdered Indigenous women who needed your help. Because protection orders are being denied due to their misuse, the only way to receive sole occupation of the family home is through a protection order embedded within an undertaking. And those are only granted by baiting your spouse into an arrest. The false baited arrest not only incentivizes someone with convenience of having sole occupation of the family home and its contents during a divorce that they will drag out intentionally for years, but also checks off one of the most important 5 tests of domestic violence used to steal full custody of the children at a later date. The false arrest is therefore very powerful in divorce court, and as such has become an epidemic in our city. As you are all aware, police are demanding funding because they cannot keep up with the demand placed upon them. 2 baited arrests, 150 phone calls to the Winnipeg Police, and 5 court dates were scheduled against the Crown Prosecutor in one coercively controlling divorce. The police wrote dozens of police reports, and yet all of the court dates with the Crown Prosecutor were thrown out, as the Crown and police knew it was just another messy divorce. What does it cost the taxpayer for police to attend to 150 calls or write dozens of police reports or prepare for 5 court dates with the Crown Prosecutor? After a baited arrest for domestic violence is achieved, the abuser can organize an arrest for breaching a protection order. Many people are confused when they are baited into an arrest. They are even more confused when their ex-partner keeps coming near them, even though a protection order was put in place, coming to their home or workplace daily. I've interviewed people. This is happening all the time. Oddly, the protection order only grants protection to one party, and there are no legal ramifications for the protected party coming into contact with the person they allege to the court and police that they need protection from. As you can see, the protection order is being used as a weapon and not as a shield. Police say people are being baited into an arrest for breaching a protection order all the time. 2 specific arrests to pass 2 of the most important tests of the domestic violence, to steal full custody of the children, and steal sole occupation of the family home and its contents are the reason why taxpayer and police resources are being abused to the extent they are. Coercive control to steal the family home to oneself exists not in just the weaponization of the protection order or the baited arrest, but in making sure your spouse can't get the false protection order thrown out in court and regain normalcy in the lives of themselves and the kids. It is said that in Manitoba, the lawyer fees associated with throwing out a protection order would cost someone $15,000 to $25,000. After a parent is falsely thrown through the criminal court system and forced to spend tens of thousands of dollars on a criminal lawyer due to a baited arrest, going through another round of incredible costs associated with setting aside a protection order forces them to forfeit the family home and their possessions for the duration of the divorce process due to cost alone. The province of Alberta has stopped coercive control and the abuse of the protection order. When a protection order is granted, the court immediately schedules a hearing within 10 business days. The province of Alberta provides both parties with a legal aid lawyer completely free of charge no matter what their income level is. The hearing deals with the sharing of the family home and sharing of possessions so that seizing the family home and its contents cannot take place.
Thanks so much, Mr. Hose. The 10 minutes allotted has expired, unfortunately, but we do have time for some questions at this point. Does anyone have questions for Mr. Hose? Yeah, Honorable Mr. Weed.
Sure. Well, thanks very much, Mr. Hose. We've had a chance to chat in person before, and appreciate you bringing. There is a lot of content here, and you know, I'm glad that you've been able to distribute it so that we can follow along. What I heard from you tonight is about the importance of protecting children, and that's the most important thing. So I really appreciate that you've outlined that as sort of the most the guiding sort of principle behind your argument, and obviously stopping domestic violence. And so you know, I appreciate your perspective. I think this is an important part of the discussion. I appreciate that you brought it here. And of course, we heard from many survivors in the last bill presentations, but it's important to bring this perspective as well.
Mr. Hose? Any further questions? Yeah, Mr. Balkin.
Well, again, thank you for your presentation. Always support public coming and doing presentations, and I know we have also met and discussed your ideas here. I'm glad that you've distributed the full package for a number of the MLAs here to be able to look at and decipher and work towards. So appreciate very much your presentation today.
Mr. Hose.
Sorry.
Yeah,
Thank
please. No, yeah, go ahead, Mr. Hose, if you'd like to say something in response.
The most important parts of the binder that I've given you are probably the first 11 pages. There's a set of recommendations in section 3, which is a little bit more encompassing in talks of family court systems, just helping the public grandparents see their children. You know, it's a shame that people can't get a protection order at the court office, and it's because of the abuse of the system in a coercively controlling divorce. And so we need to address the fact that women, men, children, whoever, neighbors, sometimes need a protection order, and if they can't get one because a couple of privileged people want to coercively control a divorce, take the lion's share in divorce, and control the children and the home, forcing someone to sign an offer to settle for far less than what they're actually owed is appalling. You know, in here, you guys would have to go through it because it talks about grandparental rights. It talks about the Clare's Law Registry. Lots of people are being baited into an arrest. You have a Clare's Law Registry, which is going to publicly put those names of those people on a public website to inform the public of these offenders. My idea for you guys is maybe we should have the person who's baiting an arrest and the lawyer guiding it also put on the Clare's Law Registry, because I have 3 men baited into an arrest, and I'm damn sure it's the same lawyer.
Thank you, Mr. Hose. Are there any further questions? Yes, Ms. Lamoureux.
Thank you, Mr. Chairperson, and thank you for your presentation. I just wanted to give the opportunity. We have a couple minutes left. I know you got cut off. If there was any last-minute remarks you did want to share.
Mr. Hose?
Sorry, yes, thank you. It's a very easy win here, you guys, and it protects the public, everybody. One, grant a protection order freely at the court counter, at the 408 York Avenue without hesitation. Two, protect both parties of a protection order. If I get a protection order put against me and my wife knocks on my door like she did 2 hours after I was served a protection order and came to my house almost every day for 8 months, and I had no idea what was going on. If she wasn't allowed to do that, and there was legal ramifications for her to do that where the protection order protected both parties, she wouldn't be able to do that. If she wasn't able to do that, she wouldn't pass the 2 tests of domestic violence to steal custody of my children. Protect both parties of a protection order is very simple. Police are being abused horribly. I can't believe how much police are being used, and they know it. The court knows it. Follow in the footsteps of Alberta and hold a hearing for a protection order every time it's applied for so that people can get their possessions back and not have to wait 4 years. Because there's post-separation abuse that comes from denying somebody all of their possessions for 4 years. And then, of course, stop granting exclusive occupation of the family home and control of the family's most valuable asset with the use of a protection order or an undertaking during a nationwide housing crisis, as it is leading to homelessness, bankruptcy, and suicide.
Thank you, Mr. Hose, and that concludes time for questions as well. Thank you for the presentation. So that concludes the list of presenters on this bill that I have before me.
No, wait, we're doing Bill 5.
Okay, my mistake. We're moving right on to Bill 5 here. And beginning with the out of town, so Miss Ida Marie Poitras. Ms. Poitras, do you have any materials that you'd like to distribute?
Not.
Okay, please proceed with your presentation.
So, honorable members of the Manitoba Legislature and Justice Committee, my name is Ida Marie Poitras, and I'm here to be a voice for Jordan Reimer and for other Manitobans killed on our highways every year as a result of impaired driving. I appreciate this opportunity to address Bill 5 and its proposed amendments to the Highway Traffic Act. While any effort to address impaired driving is commendable, the reality is that this bill does not go far enough. It fails to bring about meaningful change needed to prevent tragedies on our roads. Manitoba has an opportunity right now to be a leader in making real, lasting change. We must ask ourselves, will these revisions actually make a difference? Because in its current form, Bill 5 does not. The reality of impaired driving in Manitoba is that it is not just a traffic offense, it is the leading cause of criminal death in Canada. It's a choice that results in devastation, in injury and death, and yet our legal system continues to treat it as though driving is a right rather than a privilege. Manitoba has promoted the idea that we have some of the toughest impaired driving consequences in Canada, but British Columbia and Ontario have stricter vehicle forfeiture laws and longer driving bans. If we're taking the time to come together now to revise the Highway Traffic Act, shouldn't we be choosing changes that will actually make a difference? Because these ones don't. The failure of the current consequences as a deterrent. More than any other time in history, there are safe, accessible alternatives to impaired driving. We have rideshare services, public transportation, taxis, Uber, designated driver programs. There is no reason for someone to get behind the wheel impaired, and yet people continue to do so because the consequences are not enough of a deterrent. If a person walked into a crowded space with a smaller weapon and killed 15 Manitobans each year, the public would outcry. The outcry would be deafening. There would be immediate demands for stronger laws and harsher punishments. Yet when these same deaths are caused by a vehicle driven by an impaired driver, the outrage just does not mask the devastation. This is ludicrous. Impaired drivers are using their vehicles as weapons, whether they intend to or not hurt or kill someone, and our laws do not reflect the true gravity of this crime. The irreversible damages to families. Impaired driving is not just about statistics. It's about real people whose lives are stolen from them and the families who are left to grieve an unimaginable loss. When Jordan Reimer was killed by an impaired driver, so much was taken, not just from her, but everyone around who loved her. Jordan will never get to drive anywhere again. She will never drive with her mother, Karen, and her sisters, Andy and Nikki and Alex, to pick out a wedding dress or for them to buy baby shower gifts. She'll never drive to university to achieve her goal of earning a master's degree, because that was one of her many goals. She'll never drive to her ultrasound to listen to the heartbeat of her babies. She wanted to be a mom more than anything in the world. Yet under the current law, an impaired driver can kill someone and have their license reinstated in as little as 5 years. We're still under this proposed amendment in Bill 5. An impaired driver could kill 2 people in 2 separate incidents within 10 years plus 1 day and still legally drive again. How is that justice? How does that reflect the value of lives lost? There have been no meaningful change to this, and it's unacceptable. In strengthening Bill 5 for meaningful impact, there are things we can do. If we're serious about preventing impaired driving deaths, Bill 5 must be strengthened. And I respectfully present 3 suggestions. I'm not a lawyer, but to read through it, these weren't hard to come up with. If we're serious about preventing this, here are the 3 suggestions that I have. Number 1, in a Category B offense, the time should be increased from the current 5-year suspension to a lifetime suspense. I mean, there's just no justification for allowing a person who has seriously injured or killed someone due to impaired driving to ever operate a vehicle again. Driving is a privilege. It's not a right. And number 2, now this would be a change in Category A. And so if you have an offense in Category A, then the suspension should increase from 1 year to 5 years. This would be a stronger deterrent to impaired drivers from engaging in repeat offense. And then the third one, change the length of suspension for a second Category A offense from 5 years to a lifetime suspense. So if this impaired driver has a second offense, it proves that the driver has not learned from the first offense and he still remains a serious danger to others. So there should be no further chances for this driver. Conclusion, this is our moment to lead Manitoba. Bill 5 as it stands is weak. It doesn't go far enough to deter impaired drivers or prevent loss of life. But we have an opportunity today to do more, to do better, to make Manitoba a leader in impaired driving laws that actually save lives. So I ask you, how many more lives need to be lost before we implement the changes that will make a real difference? Let's make this bill one that truly honors the victims, supports their families, and ensures that no more Manitobans are stolen from us by the reckless choice of others. And in my closing statement, the choices we make today will determine how many more families will have to endure the unbearable loss of a loved one to impaired driving. We have an opportunity right now to set a new standard to make Manitoba a leader in impaired driving laws that truly protect our citizens. And I urge you to strengthen this bill. Make it count. Right now it's not strong. Make it a law that truly values the lives stolen by impaired drivers. Let us ensure that no more families suffer the way Jordan's has. Let us make this moment the moment that we choose real change. Thank you.
Thank you very much for your presentation. And sorry, just I have to remind the gallery that unfortunately we can't applaud after presentations here. My apologies. Questions, Minister Wiebe.
Well, I think you know, if we could applaud, I'd be applauding as well. Ms. Poitras, this is a very, very powerful and beautiful presentation. I think you reminded us exactly what this is about. These aren't statistics. This is about real people. And of course, Jordan is an example of that. That's something that we can all focus on when we're making these changes. You know, we've been very focused on working with Mad Canada, taking their direction and being iterative in terms of like, we want to do everything we can at every step of the way. So the commitment that I'll make to you that I'm made before is that we will continue to bring forward more legislation, continue to be leaders in the country, but your presentation has been very, very powerful. So thank you for being here tonight.
Ms. Poitras?
Yes. Jordan was powerful. She was a real champion, and it's an honor to be a voice for her. The loss of her is tremendous, not only to Jordan and the missed opportunities in her life, but for all of us. It's just every second of every day. And the shocking part, I mean, there's so many shocking parts, but the people who are offering condolences and saying, well, there's gonna, this person, you know, this will happen and this will happen. And I was absolutely uneducated and shocked in how soft the laws are. I had no idea you could be impaired, drive and kill somebody and get your license back in 5 years. I didn't know that you could be out of jail in 2 years. I didn't know that. So if this is our opportunity, I think we could be a real leader in this, in Canada.
Thank you, Ms. Poitras. Any further questions? Yeah, Mr. Balkin.
Well, first of all, thank you very much for your presentation. It was very moving, very thoughtful, and the fact that you didn't just bring a presentation, you brought recommendations. You know, it goes back to being part of the solution, and I sincerely appreciate that. I've got to know the Reimer family over the last year and a half, and I appreciate the ongoing advocacy that the family brings, and absolutely agree that we need to strengthen our laws here in Manitoba. Thank you.
Ms. Poitras?
It's hard to be up here. I wanted to thank you for your comments, and it would be easier if we just crawled in a hole and grieved. It would. There are days where you know, Karen and the girls, it's devastating, but they're out, and I'm helping support them, as are many people here, and it's about advocacy. Karen says all of the time, I don't want this to happen to another family, and that's what we're trying to do. We can't bring Jordan back, but we have to be a voice and try and save another family from this. But Bill 5 won't do it. It has to be stronger. This isn't going to make any real changes at all.
Thank you, Ms. Poitras. Are there any further questions? Thank you very much for the presentation, Ms. Poitras. I will now call on Mr. David Grant. Mr. Grant, do you have any written materials for the committee? Okay, please proceed with your presentation.
Sure. I, in general, support all the activities. There's been a lot of action in Manitoba over many years to minimize this scourge. We've seen people try 100 years ago to eliminate the use of the stuff. I would go back to the beginning, if I could grant me a few seconds. My relationship with alcohol is different from most people. First job out of university as a chemist was in the chemical lab of the Stroh Brewery in Detroit. So we had access to all the beer we'd want, free, within an hour of quitting work, which suggested, this is in the 60s, that it was okay for the people that worked there, because it didn't cost the company much, it was okay for the company to let people have, and they didn't, generally, I don't think there's any problem with people consuming walking to the parking lot, but it was a very different era. At the time, I was smart enough to know that riding a motorcycle after a beer was a really bad idea. I wasn't smart enough to know that riding a motorcycle was a really bad idea, but maybe I should have noticed that. Although I survived. I still have one. But I would suggest that the means that we're using right now, and this bill is one means of improving things, but I think they leave some tools unused. This is a problem around the world. I noticed in the last Formula One race where they're pushing things, people watch that around the world. The product that was most prominently displayed was Heineken's 0.0. So it gives you the experience of a beer with no alcohol. So, and they've been pushing, that company has been pushing that message for several years. And to the extent that it gets people to order a beer with their friends and be part of the party and not have alcohol in them afterwards, I would applaud that. From what we can do here, there are a couple of things. I've been a volunteer with Operation Red Nose, which, as you probably already know, we drive people home from parties or whatever, free in their car. And this year I was able to do all 11 nights. So that's whatever, hundreds of hours of driving during those hours. And I have spoken to the Winnipeg Police Board about making a slight tweak to their check stop program. Check stops in Manitoba have grown to be what I call large circuses. We get a big van, van blocks a major road, we have many police cars and many staff. Unfortunately, once they're big, they're on the internet within a couple of minutes, 5 or 10 minutes. So if you're serious about driving home drunk and you're too stupid to call Red Nose or get a place on the couch at your friend's place, if you are just going to do it, you check the internet and you can avoid those check stops. My advice to WPS was to develop some agile check stops. This is where you get 2 cars, 4 cops, and you take a less main road, like Jubilee, and you find a parking lot. The BDI is a good lot, but anyway, you just suddenly, when even though the people can see you, you divert all the cars into this lot, and you may only get 5 or 6 cars, but you can quickly check them and have them on their way or arrested, and do all that within 10 minutes. And as such, the usefulness of the internet for those kind of check stops would be less. And we noticed that Winnipeg, statistically, has a very low number of DUI people in December compared to other cities of similar size. We could say that's because our people don't drink, or we can say that our primary tool for catching them, and actually the primary tool for catching DUI people is not the check stop van, it's the parked car on whatever street, because the DUI people tend to select themselves from the rest of traffic by not moving over when that parked car comes up. And so a lot of the charges of DUI are a guy sitting in or beside his crumpled car, intoxicated. So my suggestion was to have more of these agile stops so that we could compare the percent DUI in the agile stops versus the big old ones. And if we find that the agile stops are a few times more DUI people, then we should go for way more of the agile stops, because the goal is to prevent. And if the internet has made the standard check stop ineffective, and I'm not sure if this is really suitable for legislation, but I know the government is very concerned on the issue and wants to do anything it can to make things better, make our roads safer. And that's the primary one. There are other things in use in other jurisdictions. In general, if a part of a couple that owns a car has been convicted multiple times, their license may be taken away, but the car is still out there. And the odds generally, our odds of a car being pulled over at a given moment are pretty near zero. I think it was Chicago area a couple of decades ago played with using different colored plates. So if you're a recently released felon or DUI person, your plate got to be bright yellow or bright orange in a sea of white. So as I say, there are tools out there in the world, in North America, which I think might be worth looking into. I'm not pushing any particular one today, but I think that if the vehicles to whom the DUI license removed person has access, putting funny plates, obvious plates on them would be a useful tool, because then if it's a Friday night in December and a police officer is just patrolling and he sees a yellow plate, or not yellow, but a red plate in front of him, that might be his incentive just to do a wellness check on that vehicle. So it's just a way of flagging people. We can't legally accuse them of anything, but as I say, there are tools out there, and I just support that. My wife, shortly after I met her, she was boasting to her friends that she'd always have a designated driver. And I keep saying there must be something else she saw in me, but we've been a few decades now, and she never has a temptation because I'm always the one to drive her home. I didn't mention about the brewery thing, that the last time I had a drink was end of '68, I think. So I've been without alcohol for longer than most people have been around. So, I used to like the taste of it. I was able to discern, for the brewery we had taste panels. I could tell when a product had been stored in the fridge versus room temperature for 2 weeks. I could tell the difference in nuance, but I've just abandoned it as a product to consume. And I know that the number of people who will make that step, given a suspension or not, is going to be a very small fraction. So we have to deal with the everybody else. And I think the flag license plates and certainly the stepped up enforcement, I think those are things that we can do way better on. And as I say, the check stop programs are big and good, but I think tiny stops would be somewhat better. So that's the gist of what I wanted to say. And I can be in touch with the minister later about some of this stuff. So, okay, thank you.
Thank you for your presentation. Do members of the committee have questions? Yeah, Honorable Mr. Wiebe.
Well, thank you again, Mr. Grant, for your presentation, giving us this historical perspective from your own personal perspective was interesting. It really spoke to, as you said, the changing attitudes with regards to drinking and driving. I think that's certainly a part of the efforts that we're undertaking here today, and other efforts that we've undertaken really feed to that changing attitude. And I also want to just thank you for providing safe rides home to folks. That volunteerism makes a huge difference. I can tell you from talking with law enforcement, they just really appreciate that work the volunteers do. So thank you for that.
Any further questions? Mr. Balkin.
Well, thank you, Mr. Grant. Again, always bringing your concerns forward as a citizen and a voice that's come over many decades here. Changing laws certainly have led people to, I'm hoping, make smarter and wiser choices as time goes on, much like the seatbelt legislation that was brought in that was ignored and now saves many, many lives. Taking off my legislative hat and putting on a former police hat, I know that there are those opportunities outside of static patrols when they're doing check stops. I know police do roving patrols, and they do exactly what you're saying, and there's technology like ALPRs and different things that really help police. So thank you for the contributions, and I like the idea of the different license plate.
Any further questions? No? Okay, thank you very much for your presentation today, Mr. Grant. I will now call on Ms. Karen Reimer. Ms. Reimer, do you have any written materials for the committee? Thank you, and please proceed with your presentation.
Thank you. Dear Justice Committee members, My name is Karen Reimer, and I would like to begin by saying that I stand before you as just one person from many families who have been devastated by the avoidable violent crime of impaired driving. I'm here to be a voice in the wake of my daughter Jordan Reimer's death, to be a voice to help save the lives of other Manitobans. Jordan was killed as an impaired driver. Jordan was killed by an impaired driver and his accomplice on May 1st, 2022, while she was acting as a designated driver. The tragic irony of Jordan acting as a DD and being killed, trying to avoid any harm coming to her and her friends from impaired driving, must not be overlooked. I'm here to advocate for changes that cannot continue to be painfully slow. The current snail's pace of change contributes to victims and families enduring year after year of devastation, of serious bodily harm or death to so many innocent victims. Tough on crime amendments and initiatives must mean taking action that will be impactful. I'm not opposing change to impaired driving legislation. I'm opposing weak or inconsequential legislation, and I'm advocating for stronger, more impactful legislation. I support all efforts to combat impaired driving. I wholeheartedly agree with MAD Canada's proactive prevention measures to stop impaired driving before it happens. Prevention must be our priority, but until we can eradicate impaired driving through prevention, we are stuck in a time where we must address deterrence and we must apply meaningful consequences. I acknowledge that I'm not an expert in understanding the Highway Traffic Act. I am here today as a parent and a concerned member of the public based on my best understanding of the current proposed changes to the Highway Traffic Act through Bill 5 by the NDP government. I have reviewed Bill 5's proposed amendments through the critical lens of its impact on impaired driving. The current proposed changes are weak and will not result in a meaningful impact. I am specifically addressing the section of Bill 5 that increases a lifetime suspension from 10 years to a lifetime suspension only when 2 Category B offenses occur within a 10-year period. A Category B offense includes impaired driving which results in bodily harm or death. This proposal allows the opportunity after you have seriously injured or killed someone to have a second chance to do it again before receiving a lifetime suspension. And that is only if your second killing is within a 10-year period. I have 3 questions. Number 1, what are the statistics of how many drivers have 2 serious bodily harm or fatal crashes within a 10-year period that this legislation will impact? I would think that this should be a reasonable investigation to help determine the effectiveness of this proposed change. We need the statistics to make informed decisions if this legislative change is going to functionally, effectively, and truly save lives. Number 2, my second question. If the proposed changes only affect a minimal number or possibly no impaired drivers each year, then how is that being tough on impaired driving and helping save Manitobans? My third question is, after reviewing all of the possible areas of the Highway Traffic Act that could be strengthened, why did Bill 5 focus on an amendment that would have such a minimal impact? It is truly time to recognize that a vehicle becomes a dangerous weapon when drivers ignore the laws of the road. A current Category A and B, there is a current Category A and B offense table which reflects 10 steps of increasing number and severities of offenses that increases number and severity of offenses and imposes suspensions for using a vehicle as a weapon while driving impaired. I ask, are there any other comparable 10-step tables that offer a criminal the opportunity to reoffend using a weapon such as a gun or a machete before they have a lifetime ban on using that weapon? Make no mistake, the vehicle is a weapon once the driver is impaired. I propose 3 different amendments to Category A and B offenses that I feel will be more likely to have impactful changes to save lives. Proposal 1, a first Category B offense should result in an increase from the current 5-year suspension to, did I say Category B? Category B offense should result in an increase from the current 5-year suspension to a lifetime suspension. It is simple, one and done. Driving is a privilege, it is not a right. A person should forfeit this privilege after their first bodily harm or death offense. MPI published the statistics for Category B offenses for 2024. They tell us 133 impaired drivers and victims, 15 fatalities, 118 seriously injured individuals. Without even knowing the missing statistics for the proposed Bill 5 amendment, we can be confident that stopping 133 Category B offenders the first time from ever driving again will be more impactful in the number of people that it is going to apply and save. Bill 5 does not address Category A offenses, and therefore these remain unchanged. The next proposals, number 2 and 3, address this. Proposal 2, changing the length of sentence of a first Category A offense from 1 to 5 years. A Category A offense includes impaired driving that does not cause bodily harm. This increase for first-time impaired offenses will act as a stronger deterrent to impaired drivers from engaging in a repeat Category A offense or engaging in a more devastating Category B offense. It will send a strong message and a commitment to get tougher on impaired driving crimes. Comparatively, we can analyze the statistics provided by MPI on how many drivers on an amendment to the Category A offense would affect. 2024 data reveals the alarming number is 2,031 Category A offenses. It is therefore more likely a change in legislation to first Category A offenses would be a stronger deterrent to the greater number of impaired drivers. Proposal 3. Changing the length of suspension for a second Category A offense from 5 years to a lifetime suspension. The second offense tells us that they did not learn the first time. How many chances are we going to give them to be lucky and then not lucky and kill somebody? No more chances. In summary, I have the following recommendations. Number 1, legislative changes to impaired driving must be impactful. Number 2, data analysis must be used to make informed decisions to drive and guide these impactful legislative changes. Number 3, a formal FIPA data request to MPI is recommended to analyze how many people will be impacted by the proposed Bill 5 amendment change as it stands to Category B offenses within a 10-year period. Number 4, changing the license suspension for first Category B offenses from 5 years, first Category B offenses from a 5-year suspension to a lifetime suspension will be impactful. It is simply one and done. There is no need for a second chance for someone to kill somebody. Number 5, changing the license suspension from first Category A offense from 1 to 5 years will be impactful. Sadly, this 2024 annual statistic of 2,031 is on the incline. Changing the license suspension for a second Category A offense from 5 years to a lifetime suspension will again be impactful. No more chances to kill people. The 3 proposed amendments reviewed here are reasonable, within reach, and meaningful changes to the Highway Traffic Act, and all Manitobans should stand behind them. There are so many things that are wrong about putting the rights and conveniences of the impaired driver over the victims. Consider this. Today we are only talking about license suspensions. Like, my goodness, seriously reflect on that. Why is the government proposing a legislative change that sends the message that privilege to drive for a criminal who has killed somebody is prioritized over the innocent victim's basic rights to be alive or the safety of future potential victims? As it stands, the message is that killers should have a second chance to drive, but all the victims, like Jordan, don't get to walk or breathe or on this earth ever again, forever. I feel like having to be here today is inherently adversarial, and it really shouldn't have to be. We should all be the same team fighting to eradicate impaired driving. Impaired driving legislation must be nonpartisan. It is a humanity issue, and we must partner and band together to save lives. Just think what we could accomplish if victims and families had a real voice of collaboration at the table with the government and the justice system. Please consider this, and please consider What would you fight for if it was your child killed by an impaired driver? Let's create and pass meaningful bills that are not inconsequential but are in the best interest of all Manitobans. I close now by thanking you for the opportunity to contribute to the discussion on impaired driving amendments. I will leave you with one of my favorite quotes. It is by Martin Luther King Jr. Our lives begin to end the day we become silent about the things that matter. Jordan's life mattered. So many innocent victims' lives destroyed, and those victim innocent families destroyed by impaired driving matter. Thank you, Karen Reimer, on behalf of Jordan's family, her dad, Doug, her sisters, Alex and Nikki, and Andy Reimer. Thank you.
Thank you very much, Ms. Reimer.
Sorry, the chart, table A, B, and C.
Well, yeah, is there leave in the committee to allow Ms. Reimer to finish what she wanted to say?
Yeah, leave.
Okay. Leave has been granted. Please go ahead.
Thank you. The tables that I dispersed for you to review are, table A is just how the current 10-step chance after chance after chance is currently in the Highway Traffic Act. Table B reflects the recommended proposed changes and how some of those steps would just automatically be eliminated by being tougher on earlier steps for Category B and Category A. There's an explanation in that chart, and then at the end, Table C would be the resulting, more simplified 3-step chart or table that would reflect the changes.
Thank you very much, Ms. Reimer. So we'll have 5 minutes for questions now. Honorable Mr. Weed.
Thank you. Thank you, Chair. And Karen, I'm so sorry. So sorry for your loss. And you're absolutely right that Jordan's life mattered. And your advocacy continues to be such an important part of this conversation. So I appreciate you being here. I appreciate everybody who's come to support you, the community that's come to support you. I'm encouraged to hear that you're, eager to dig into this legislation. I think there's lots more we're doing. We're working with Mad Canada. I encourage you to work with them so that we can all be on the same page. And I think there's lots that we can do. So just thank you. Thank you for everything you've done, and thank you for coming to represent Jordan.
Ms. Reimer, would you like to respond?
Am I allowed to respond with my own questions, or?
It's unfortunately the questions, the purpose here is for a committee to ask questions, and then you would respond to the questions if you'd like.
Well, I guess just in terms of I have partnered with MAD. Recommendations toward Bill 5 work?
Yeah.
Yeah, Honorable Mr. Weave.
Yeah, they've submitted a brief to the committee, and they are in full support of Bill 5 as presented. So I think there's always more work to be done, and that's what we're talking with them about, is what the next steps are. And that's where your input, I think, is going to be absolutely vital. So we can help make that connection if you don't have that already with the people that are working on the policy on their side.
Are there any further questions? Yeah, Mr. Balkin?
Well, thank you very much, Karen, for coming to committee tonight. And I know the advocacy work that you, Doug, and your family have done is instrumental in moving the mark forward, and will continue to work to move this mark forward. I'm just wondering, with this table that you've put forward, or the suggestions, do you think there'll be more denunciation of the crime of impaired driving, whether it's an A or B offense, if people see the punch that comes with such a proposal?
I absolutely do. I mean,
Ms. Reimer, sorry, I just need to acknowledge you, and then you can please respond. Ms. Reimer.
I absolutely do. I feel like the majority of our effort should be put forth to prevention, and MAD National is pushing for anti-impaired technology in all new vehicles, and I think that's the most brilliant saving measure that we're going to see. The U.S. is already approved it, and it is, I thought it was 2026, but I believe it's 2027. That is supposed to come into place, unless that changes with the current government. And I know that, Canada is following suit. If we can get that technology, and you mentioned seatbelts earlier, people were opposed to seatbelts, but if we can get that new technology into vehicles, we could, in our lifetime, eradicate impaired driving. And we wouldn't be standing here talking about consequences and punishments and whether we give people a second try. There wouldn't be a need for a second try. Nobody would do it, and everybody would be safe. But
Thank you so much, Ms. Reimer. Are there any further questions? Thank you very much for your presentation. I will now call on Mr. Garth Steek. Mr. Steek, do you have any written materials for the committee? No, I don't. Okay, please proceed with your presentation. Thank you.
Mr. Chairman, members of the committee, I appreciate this opportunity to be here this evening to speak to the proposed amendments to the Highway Traffic Act. If I were to ask any of you what the most important aspect of your life is, I dare say without equivocation you would respond, my family. If you could, for 5 seconds, just close your eyes. That's all I'm asking. I want you to envision that person that you love more than anything in the world. I want you to think about what it's like to get that phone call at 2 o'clock in the morning telling you that person has been killed by an impaired driver. The imagery is horrific. It's unimaginable. I'm 75 years old. I had 3 children, I have 2. I have 2 grandchildren. I'm here in support of the Reimer family, who I think are quite simply extraordinary in the journey that they have made to come to this amendments committee. Mr. Chair, you're entitled to your own opinion in a situation like this, but you're not entitled to your own set of facts. The facts before us are irrefutable and they're indefensible. As the Minister of Justice knows, in 2024, 15 people died because of impaired driving, killed by impaired drivers. 118 were injured with life-threatening injuries. I happened to attend one of those events and I saw what those people looked like. It's a horror you never forget. Between 19 and 23 in Manitoba, 91 people died, 350 were injured, many beyond repair. They're living lives of misery. In Canada, in the most recent number, 2021, 460 people died because of being hit by impaired drivers. I think this amendment, and I'm only speaking to one aspect of it, the 5-year aspect. I think well-intentioned, but very frankly, flawed, deeply flawed. As has been noted by Ms. Reimer, Ms. Poitras, at the end of 5 years, you're saying to that person, you know what? You spent 2 years in jail. I'm going to give you a gun back, and if you go out and kill again, maybe we'll look at it again. That's incomprehensible. Everyone has a right to be safe. Safety is the cornerstone of a healthy, prosperous community. So what's the solution? Well, I thought Ms. Reimer, in her very eloquent presentation, talked about the importance of technology. But that hasn't arrived yet. When I was preparing for this, I looked at countless data. And what stunned me is everybody says, you know, Manitoba's so tough. No, we're not. We're not the toughest jurisdiction in the country. You know where the toughest jurisdiction is? It's Ontario. And what happened in Ontario? On January 1st, the Highway Traffic Act in Ontario was amended, whereby if an impaired driver kills or seriously injures a person, it's an automatic lifetime suspension, period. Period. Now, I'm suggesting to you that that's what should happen here. Ms. Reimer spoke to aspects A and B. I'm not going there. She's covered that and covered it well. What happened to these people was not an accident. It was an act of profound negligence. The horror, the nightmares, the anguish, the pain is incalculable. No family should have to live through that. When I was reviewing for this, I happened to note, Mr. Chair, that you're a former firefighter and a paramedic, a noble profession. I bring that up because of the fact of what's the importance of being the leader in legislation. The importance is this. You'll well remember that Alex Forrest brought forward legislation here to ensure that firefighters who were exposed to carcinogens would be compensated. That's groundbreaking legislation, and the NDP brought it in here. Why is it important? Because of the fact that it set the bar high, and today across North America, that legislation is in place because of that initiative. So I'm saying to you here, do not be followers, be leaders. Have the courage to stand up and say, what happened to the Reimer family, what happens to people every year is wrong, and we're going to stop it. I followed this saga in the paper. It's simply astonishing what this family has gone through. The courage, the determination, the grace, and the dignity that they have brought to this table. I don't think I know anybody who else could do it. When you're going through law school, one of the things that's pounded on you relentlessly is Section 91 of the Constitution. And the reference is peace, order, and good government. Now, the section actually talks about the division of powers between the provinces and the federal government. But I dare say that for the vast majority of Canadians, peace, order, and good government is what we are looking for. Amend this legislation for lifetime bans. I don't think that you can give peace to the Reimer family. But I think you can give them order. I think you can give them order by passing a lifetime ban after committing this heinous crime. I also think that you can give them good government. This is not a political issue. This has nothing to do with party ideology. It has everything to do with what is simply right or wrong. And so when I'm standing in front of you, when this legislation comes into effect and you amend it to the point where nobody drives after one of these offenses, I would expect the opposition will be supportive. Anything less would be profoundly wrong. It's well marked that the arc of the moral universe is long, but it bends toward justice. It's time to do justice to the Reimer family. It's time to do justice to the memory of their daughter. It's time to do justice to the hundreds of Manitobans who died for no reason. And finally, it's time to do justice to those Manitobans who are going to die in the future if you don't bring in legislation that is profound. Be leaders, not followers. This is weak legislation. I said to you that I had 3 children, I have 2. I didn't lose it. My son, 39, 6 years ago, to a drunk. I lost him in a horrific accident. It was not preventable, and there was no one to blame. But I'm going to tell you to this day, I am haunted. I have nightmares. The pain and the suffering that my family have endured for no reason is profound. You can make a difference coming out of this meeting. Now, I know that after a presentation of this nature, there's the opportunity to question the presenter. I'm hoping that somebody can explain to me how you think that a 5-year ban is sufficient. And I'm challenging anybody at this table. You may have gotten the idea. I enjoy a debate. Let's talk. Mr. Chairman, thank you.
Thank you for your presentation, Mr. Steek. We'll go to Honorable Mr. Wiebe.
Yeah, thank you very much, Mr. Steek. Unique perspective because you're able to bring the personal as well as your professional expertise to the table. So I really appreciate that. Certainly happy to help walk you through the sort of legal parameters with which we're bringing this bill forward. What I will say is that this will once again bring Manitoba to be amongst the leaders in Canada of drunk driving legislation, impaired driving legislation. And we're confident in what we're bringing forward that it will withstand the test, but that it's also some of the strongest legislation that we can bring forward. But again, happy to unpack it for you, help you understand, and appreciate your perspective.
Mr. Chairman, can I respond?
Yeah, you can certainly respond. I will just remind that we can't debate in this forum at the committee. It's more of a question and response. But please feel free to respond. Yes. Yes.
You say you're bringing forward some of the most strident legislation. With all due respect, I totally disagree. You are giving somebody a second opportunity after 5 years to go out and commit this heinous crime again. Furthermore, you talk about the strength of the legislation. The legislation in Ontario, which by the way came into effect on January 1 this year. You can see the extensive coverage on CBC TV. I'm not making it up. And so I'm saying to you, if you believe that you've got the strongest legislation, this is good, you can improve it.
So the order of questions now is supposed to go on to a member of the opposition. If there is leave from the opposition for the minister to respond, I could allow that.
Yeah, just
Honorable Mr. Wiebe.
You know, I think there's some confusion. Ontario, it's just death. This is death and bodily harm. I would just offer, can we just find some time after this? This isn't the forum for a debate, but I'm certainly happy to just give all the information and make sure that you're aware of what we're working with here. So thank you.
I appreciate that.
Mr. Steek.
That this 5-year program is simply not sufficient.
Thank you, Mr. Steek. Are there any further questions? Mr. Balkin.
Yes, well, thank you, Mr. Sleek, for the presentation, and you bring some remarkable points forward that certainly resonate with me from my past experience. Unfortunately, I've been one of the ones that's had to deliver the horrific news to families regarding the loss of a loved one more times than I wish to remember. So I agree with you absolutely that more needs to be done and that more can be done. I'll ask the same question. Do you think that this will be a deterrent or a denunciation to individuals if they know that they would seek much greater sentences for their license prohibition should they have a second or subsequent offense?
Mr. Steek.
Through you, Mr. Chair, to Mr. Balkan. The kind of fools that do this don't care. Let's not kid ourselves. This is not about reformation. This is about protecting people. And I totally empathize with you having to tell a family of the worst nightmare they could possibly envision. But the fact remains is that until there is technology to preclude people from getting behind the wheel drunk, I don't know that it's either a denunciation or a deterrence, but I do know this, that it's appropriate punishment, and that's where I come from.
Thank you, Mr. Steek. Any further questions? Thank you for your presentation today, Mr. Steek. I will now call on Jacqueline Robertson. So Jacqueline Robertson. We'll just check if she's online. You just be patient. One moment. This is the last presenter of the committee, so I'll give one more opportunity. Jacqueline Robertson. Okay, so that concludes the list of presenters that I have before me. In what order does the committee wish to proceed with clause-by-clause consideration of these bills? Mr. Balkan?
I would suggest Bill 2, moving to Bill 5.
Mr. Balkan has recommended Bill 2 to Bill 5. The recommendation from Mr. Balkan is to go through Bill 2 and then through Bill 5. Do we agree?
Agreed.
The rest of the bills.
Yeah. So following Bill 2 and Bill 5, we'll move on to Bill 31 and 42 as well, as we don't have presenters for those. So we will now proceed with clause by clause of Bill 2. Does the minister responsible for Bill 2 have an opening statement?
I do.
Honorable Minister Wiebe.
Thank you, Honorable Chair. Good evening. I'm pleased to be here to see Bill 2, the Provincial Court Amendment Act, also known as Kira's Law, through this committee stage. This bill will make amendments to the Provincial Court Act regarding continuing education for provincial court judges and judicial justices of the peace. At present, to be eligible for appointment as a provincial court judge, an individual must participate in continuing education on sexual assault law and social context, which includes systematic racism and systematic discrimination. The current legislation does not address continuing education for judicial justices of the peace who perform a number of the responsibilities under the Act. With the proposed amendments, candidates seeking appointment as a provincial court judge or judicial justice of the peace will be required to participate in the same continuing education as prospective judges. This bill responds directly to calls from survivors of gender-based violence, many of whom came to this very room to present and showed incredible courage and resilience when they shared their stories with us at committee in the last session. I want to acknowledge once again all of them for their contributions and for their advocacy on this critically important issue. In particular, I want to acknowledge Dr. Jennifer Kagan Viader, the mother of Kira Kagan, who informed us of the importance of these changes and how introducing Kira's Law will help prevent horrible acts of domestic violence and coercive control in Manitoba. Dr. Kagan Viader's tireless efforts have helped us to lead in this legislative change here, but also federally and in Ontario. I'd also like to thank the member for Tyndall Park for her collaboration and for her dedication, introducing her own private member's bill, which we've built upon by adding additional topic areas and additional funding provisions. I'd also like to thank the Minister of Families for her contributions and for introducing this bill going back a number of years now in opposition, bringing it to the attention of the House. In addition to the continuing education of judicial justices of the peace, training will be provided on 3 new topics: coercive control in IPV and family relationships, the experience of Indigenous persons, and the 2S LGBTQIA+ persons in the justice system and in society. And of course, intimate partner violence. The proposed amendments build upon and expand the existing continuing education for prospective provincial judges. And the amendments are intended to ensure that those in decision-making positions have awareness of these subjects and can use this information to be more fair and more equitable. The Chief Judge will continue to have authority to establish continuing education seminars for judges, and now to establish training for judicial justices of the peace. The legislation ensures seminars are developed after consultation with persons, groups, or organizations the Chief Judge considers appropriate. This may include survivors of sexual assault and IPV for seminars on sexual assault law or IPV, and representatives of Indigenous and 2S LGBTQIA communities for seminars on social context and community experience. The Chief Judge continues to be required to report annually on any seminars that are held regarding specific topics. I want to acknowledge members of the judiciary, including Chief Judge Rolston, for their commitment to judicial education and for its continued improvement and enhancement. We move to introduce this as a government bill to ensure that the funding provided for continuing education seminars and other sessions does not lapse. This will have a major impact. The change will ensure that core education funding for these sessions can continue uninterrupted, and that this important education can continue regardless of the fiscal year in which it takes place. Like the advocates who have championed this legislation, we will not stop pushing for change. Our public safety strategy outlines numerous actions that our government will take to further support survivors of gender-based violence and coercive control, and to ensure that we are advancing reconciliation throughout the justice system. I'm committed to working across government, including with my colleagues, the Minister of Families, and others to do just that. Thank you for your time. Looking forward to seeing this bill move forward through the committee stage. Thank you, Honourable Chair.
Thank you, Minister Wiebe. Does the critic from the official opposition have an opening statement? Mr. Balkin.
Yes, well, thank you again for the opportunity to speak to this. This will be second or third time that we've had the opportunity to speak to this in its various forms as this moves forward. I'm going to be short on my remarks because I've made them during debate, and I've also talked to this extensively. But what I will say is we wouldn't be here today if it was not for the efforts of the MLA for Tyndall Park. And I would like to thank her for her efforts in moving this bill forward as her bill in 2024, and then again seconding it and making sure that it comes to fruition tonight. What I will say is that I know she put in hours and hours of consultation and time, and commendable the work that she did in order to bring this bill forward. I am cautiously speaking on the fact that I know the the judiciary is very concerned about legislation trampling on judicial independence. And I have always been for and about judicial independence, making sure that there is no untoward pressure from legislators or legislation. And we heard from Ms. Dawes tonight, and we are creeping in on that judicial independence that is so needed in our democratic society. So with those remarks, I will end my remarks for tonight, Honorable Chair.
Thank you, Mr. Balkin. So during the consideration of a bill, the enacting clause and the title are postponed until all other clauses have been considered in their proper order. Shall Clause 1 pass?
Pass.
Clause 1 is accordingly passed. Shall Clause 2 pass?
Pass.
Clause 2 is accordingly passed. Shall Clause 3 pass?
Pass.
Clause 3 is accordingly passed. Shall Clause 4 pass?
Pass.
Clause 4 is accordingly passed. Shall Clause 5 pass?
Pass.
Clause 5 is accordingly passed. Shall Clause 6 pass?
Pass.
Clause 6 is accordingly passed. Shall Clause 7 pass?
Pass.
Clause 7 is accordingly passed. Shall Clause 8 pass?
Pass.
Clause 8 is accordingly passed. Shall the enacting clause pass?
Pass.
The enacting clause is accordingly passed. Shall the title pass?
Pass.
The title is accordingly passed. Shall the bill be reported?
Agreed.
Agreed. The bill shall be reported. Does the minister responsible for Bill 5 have an opening statement?
I do.
Honorable Mr. Wiebe.
Thank you, Mr. Chair. I'm pleased to be here to see Bill 5, the Highway Traffic Amendment Act, Impaired Driving Measures, come and pass through the committee stage. This bill brings forward amendments that represent a pivotal step in efforts to enhance road safety and to protect Manitobans from the devastating consequences of impaired driving. 10% of fatal collisions in Manitoba in 2023 included impaired driving as a contributing factor. But those numbers aren't why we're here today. It's because of stories like Jordan's and so many others. So many families, communities, and individuals who've been touched by impaired driving. It's a problem that touches the lives of far too many individuals, far too many families, and far too many communities. That's why it was so important for us to have consulted with stakeholders such as Mothers Against Drunk Driving, who fully support this bill to introduce these changes and to take action to protect communities and improve road safety. We want to send a message that there are real and serious consequences in Manitoba for choosing to drink and drive. The amendments presented here today will increase the length of the automatic driver's license suspension following a second conviction of impaired driving causing death or bodily harm within 10 years of a first offense. The suspension will be increased from 10 years to a lifetime suspension. The amendments also require that all drivers convicted of this type of offense will be prohibited from driving with any alcohol in their blood, a 0% blood alcohol concentration, which will be a monumental step forward. For a first conviction of this type of offense, the driver will be prohibited from driving with any alcohol in their blood for 7 years. For a second conviction, this now becomes a lifetime prohibition. The bill will also include sanctions for breaching the 0% alcohol prohibition, which will mirror the current immediate roadside prohibition regime, sanctions imposed for drivers that blow a warn on approved screening device. This includes the following: license suspension starting at 3 days for the first breach and escalating for each subsequent breach from 15 to 30, and then to 60 days. Vehicle impoundment for 3 days after the first breach, and increasing for each subsequent breach from 7 to then 30 days. Referrals to Addictions Foundation of Manitoba of driver's assessment following a second breach within that 10-year period. Ignition interlock is now imposed following a third breach. An administrative penalty of $400 following a first breach and increasing with each subsequent incident. And license reinstatement fees are increased. The proposed bill is intended to strengthen road safety in Manitoba by imposing new and stronger licensing sanctions on drivers who are convicted of these impaired-related offenses that cause bodily harm and death. When a driver ignores basic safety rules, when they kill or even injure another person because they chose to drive impaired, they have demonstrated that they cannot responsibly consume alcohol and drive. The corresponding 0% alcohol prohibition on these offenders will enhance road safety by separating their alcohol consumption from driving. Some of the proposed changes, such as increasing the automatic license suspension following a second conviction for impaired offenses causing bodily harm and death, would come into force immediately on royal assent. And the remaining provisions will come into force on proclamation, working with Manitoba Public Insurance, giving them time to make the changes within their systems. This is about making our roads safer. This is about saving lives. We're happy to work with MAD Canada. We're happy to work with the community. I want to thank everybody for taking the time to be here tonight. This is not the end. We're going to continue to work on this, and I invite you to be a part of it. Thank you, Honourable Chair.
Thank you, Minister Wiebe. Does the critic from the official opposition have an opening statement? Mr. Balkin.
Well, thank you, Honourable Chair. And it actually saddens me that we have to look at strengthening impaired driving laws when it is the highest contributor to deaths among young people within Canada, and the fact that we tout that we have the strongest laws in Canada in Manitoba is factually wrong. We don't, and we can do much, much better as we go further along. We talk about enhancing road safety, and again, impaired driving is a contributing factor in approximately 10% of motor vehicle collisions. And we've heard the statistics tonight delivered so eloquently by a number of people, whether it be Manitoba-wide, whether it be Canada-wide, to the number of people that are injured and that are killed by impaired driving. I also note that MAD Canada does support this bill as written, but they would support this bill as written because it does strengthen what is there right now, but much more strengthening needs to be done to this bill to have effective impact on the lives of many, many Manitobans and visitors to our province, whether it be provincially, nationally, or internationally to our province. To have a second conviction for a lifetime when you've taken somebody's life away seems counterproductive and seems to fly in the face of justice. Justice must not only be seen to have been had, but must also be had for the victims and the families of this. Having a second opportunity for a lifetime prohibition seems to be allowing the perpetrators more leniency than a family who has to have a lifetime sentence of not having their loved one, not having those memories, not having everything that goes with families and life. Deterrence and denunciation is a cornerstone of law, and we have to make sure that we have those deterrence and denunciations for individuals, particularly our young drivers who are coming into the system. Much like I mentioned earlier about seatbelts, when individuals learn something initially and it's repeated over and over, then they get the idea. And if a young driver knows that they will lose the privilege of driving or operation of a conveyance, then that sticks with them. And so, when we also look at other offenses, and I know it's more criminal code, but such as murder and manslaughter, the judge has the opportunity on a first offense to do a lifetime prohibition for weapons, a lifetime prohibition for firearms. I don't see this as any different. A vehicle is used as a weapon, and a person should suffer a lifetime ban when they're causing death. So with that, Honorable Chair, I just repeat that I think there's so much more that we can do to strengthen our laws, and as legislators, we're here today. We have the opportunity today at this committee to make meaningful changes, and I think it's incumbent on each and every one of us to do just that.
Thank you, Mr. Balkin. During the consideration of a bill, the enacting clause and the title are postponed until all other clauses have been considered in their proper order. Also, if there is agreements from the committee, the chair will call clauses in blocks that conform to pages, with the understanding that we will stop at any particular clause or clauses where members may have comments, questions, or amendments to propose. Is that agreed?
Agreed.
Agreed. Shall clause 1 and 2 pass?
Pass.
Clauses 1 and 2 are accordingly passed. Shall clause 3 pass?
Pass.
Clause 3 is accordingly passed. Shall clause 4 pass?
Pass.
Clause 4 is accordingly passed. Shall clauses 5 and 6 pass?
Pass.
Clauses 5 and 6 are accordingly passed. Shall clause 7 pass?
No. I have an amendment.
Okay, I hear a no. All right, I heard a no from Honorable Mr. Wiebe.
Thank you very much, Honorable Chair. I have an amendment to propose to the committee.
Do I move the amendment, then speak to? Yeah.
Yeah, so you move the amendment, we'll do it whether it's in order or not, and then we'll open it for debate.
Thank you, Honorable Chair. I move that clause 7 brackets 3 of the bill be amended in the proposed subsection 264 brackets 1.2.3 by adding unrelated after 2.
It has been moved by Honorable Mr. Wiebe that Clause 7.3 of the bill be amended in the proposed subsection 264, 1, 2, 3 by adding unrelated after 2. The amendment is in order, and the floor is open for debate. Honorable Mr. Wiebe.
Thank you very much, Honorable Chair. This amendment tonight is with regards to a drafting error that was made with Bill 5 that we would like to resolve here at committee. The wording of 2 separate sections is ambiguous, as it should be referring to 2 separate incidents. These amendments will establish internal consistency within the Act and amend the bill to reflect the intent of the legislation.
Thank you, Honorable Mr. Wiebe. Does anybody else want to join the debate, speak to the debate?
I have an amendment to bring forward.
We're going to vote on this one first.
He has to be recognized.
Mr. Balkin.
I have an amendment.
Mr. Balkan.
Honorable Chair, I do have amendment to bring forward, but based on this information, I would request a 5-minute recess to adjust some amendments that I have.
Mr. Balkan has requested a 5 minutes recess. Is that agreed?
Agreed.
Agreed. We'll take a 5-minute recess. order. Mr. Balkan, you have the floor.
This is the one here.
Yes.
This one.
Mr. Balkan.
Honorable Chair, I'll be moving a sub-amendment to the Minister's amendment. I move that the amendment to Clause 7.3 of the bill be amended by striking out everything after "be amended" and substituting the following by replacing the proposed subsections 264, bracket 1.2.3 unbracket, and bracket 1.2.4 bracket with the following: lifetime suspension for certain impaired offenses, 264.1.2.3, despite, despite subsection 1.1, a person is disqualified from driving a motor vehicle for the rest of their life, and their license and right to have a license is permanently suspended if A, they are convicted under either of the following provisions of the Criminal Code: 1, subsection 320.14, subsection 3, operation while impaired causing death; or 2, subsection 320.15, subsection 3, failure or refusal to comply with the demand, accident resulting in death; B, they are convicted under either of the following provisions of the Criminal Code: 1, subsection 320.14, bracket 2, operation while impaired causing bodily harm; 2, subsection 320.15, bracket 2, failure or refusal to comply with the demand, accident resulting in bodily harm; and they are subsequently convicted of a designated impaired offense not referred to in Clause A, or of an offense listed in Clause A or A.1 of the definition Category A offense; or C, they are convicted of a designated impaired offense not referred to in Clause A or any other offense listed in Clause A or A.1 of the definition Category A offense, if the person under the age of 18 years was a passenger in or on the conveyance at the time material to this offense.
Thank you, Mr. Balkan. It has been moved by Mr. Balkan that the amendment to Clause 7.3 dispensed. The sub-amendment is in order, and the floor is open for debate. I just need to address that a few of the words from that sub-amendment were spoken incorrectly into the system. Is it the will of the committee to allow that we use the word written in the actual sub-amendment to be had in Hansard? Agreed. Thank you. Okay. So the sub-amendment is in order, and the floor is now open for debate on the sub-amendment. Mr. Balkan.
Well, thank you, Honorable Chair. Appreciate the opportunity. And I think listening to the presenters tonight, every single one of our presenters on this particular bill spoke eloquently and spoke factually about our present Highway Traffic Act and the infractions that can happen and the punishments as a result of that. I think it's safe to say that all of us in committee want to have a safer Manitoba. We want to have safe roads, and we want to be able to enjoy our roads with the most safety and well-being that we can, not only for ourselves, but for our families, our friends, and our neighbors that use the roads. I believe by moving these sub-amendments, we can strengthen the Highway Traffic Act to have real impact and real change for Manitobans that have suffered impaired driving. The devastation that happens to individuals and to families that have to suffer through impaired driving should not have to happen, and putting in safeguards is my hope that what's happened to the Jordan family, or I'm sorry, to the Reimer family and to many, many other families across Manitoba over the years doesn't have to change, or does not have to happen to them again. I think this change is paramount, and I think we've heard loud and clear from all of the presenters that there needs to be some significant movement and not the limited movement that is moving forward in the bill as it is presently stated. So this will certainly allow anybody who has committed an offense and causes death to lose their license for a lifetime prohibition in Manitoba, making sure that we mirror some of the toughest driving laws and bringing Manitoba back into compliance with tough driving laws and tough denunciation in our province. It moves the marker forward with individuals that create impaired causing bodily harm, in that they don't have to commit a second offense, a second designated offense. It could be any impaired driving offense that they commit subsequent to that, and they lose their license, not having to commit an impaired driving causing death or an impaired driving causing bodily harm. And it's any time that they do this after their sentence for their first conviction of impaired causing bodily harm. And it actually brings a third and very important piece of legislation forward, and that is if you have a passenger in your vehicle that is under the age of 18. And this is significant for law enforcement. I've talked to many law enforcement officers about this, and the amount of times that vehicles are stopped with children, with babies, with individuals that are under the age of 18, those young minds that can easily be influenced. If they are involved in impaired driving while having a child in their vehicle, it would result in a lifetime prohibition of their driver's license. I think bringing these amendments forward, I know will have the effects and ramifications that it very well should for our province, making sure that individuals are brought to justice for their wrongdoings. We must remember that driving is a privilege in this province. It is not a right. And the privilege to drive ends when you consume alcohol, when you take somebody's life, when you take or cause significant injury to individuals. Your right when you're driving impaired with a young child, a baby, or anybody under the age of 18 in your vehicle ends. Your right ends there and your privilege ends. So it's very important to make sure that we note that it is a privilege in this province, and that privilege needs to be removed if there is contravention of our laws. So with those words, I thank you, Honourable Chair.
Thank you, Mr. Balkin. Are there any further speakers in the debate to the sub-amendments? Honourable Mr. Wiebe.
Well, thank you, Honourable Speaker. And I think one of the most encouraging things that I heard today is that there's a willingness for further collaboration and a call from families to put down partisan differences to see this as a common good, and I think that's what we want to be working together on. I also heard from members, from presenters here tonight, and families that I've spoken to, that they understand that deterrence isn't the only answer. That there is no, unfortunately, any single piece of legislation that will solve impaired driving. But you know, the understanding that this is one step on an important path to making our streets safer. But also make sure that folks understand, the member opposite has blurred the lines a little bit. The jurisdiction, of course, here in Manitoba is under the Highway Traffic Act. It's about imposing road safety. That's what we're talking about here today. The member opposite knows well, I think hopefully he's sharing with the families the federal government's responsibility. Parliament, of course, imposes the stronger punishments for crimes. And I encourage to hear family talking about steps that the federal government can take when it comes to interlock or testing systems in cars. I think that's a great idea, and I hope that Parliament acts. Federal election ongoing, so I hope to hear more from the federal parties about that, no matter the stripe. The member of the committee here also, of course, knows, and I know appreciates, and hopefully, again, he's sharing with the families just how important the role of the Attorney General is in this process. The responsibility, part of the responsibility that we have here is to ensure that any legislation that we bring forward is legally durable, that it'll stand up to any kind of legal scrutiny. And so there are some constitutional considerations that I think are relevant to this conversation and relevant to consider. For instance, a lifetime suspension after one conviction is arguably an attempt to impose a punishment for a crime rather than being, as I said, a true measure to improve road safety. That would be a federal responsibility, and we again call on the federal government to take tougher action on impaired driving. Also, lifetime suspension after the first offense risks being challenged, therefore, in court as being a disproportionate response to the pursuit of having safer roads. One very important distinction that I want to make sure that folks understand, that again, it might have been unintentional, but I want to make sure that we're not misleading anybody. And so I want to be clear that the courts still and already have and still have the full discretion in the case of an impaired driver to impose a longer prohibition if warranted as part of the sentencing. The judges have that ability to do that. And so I want to make sure that that's clear. And, you know, I think, again, this is an opportunity for us to come together to understand that the legislation that we've brought forward, fully endorsed by MAD Canada, the important policy work that they do is not just in Manitoba, it crosses all boundaries in the country. They have a very firm sense of what is good legislation, what is working in other provinces, and what we can do here. We were leaders in Manitoba. When I first got elected, every single year there was a piece of legislation that was brought forward by an NDP government specifically on impaired driving, and it every year strengthened and moved the needle in terms of making our roads safer. I think we've fallen behind. So it's time to regain that ground. And I do feel that there is a bipartisan or a nonpartisan movement here. So I hope that we don't you know, try to use specific situations to bring legislation that doesn't work, but instead find ways we can work together and do this each year. I invite everybody to come forward. MAD Canada has been a great partner, and so I think they are the best representatives of some important work that we can do. And so I encourage the member opposite to also meet with them and understand the good work that we're doing. Again, what are we talking about here? We can talk about statistics. We can talk about the specifics about what is allowed in terms of our constitutional commitments. What I want to say very clearly is that I'm continuing, I'm dedicated to this. This is going to be something that I'm going to do every single year as Justice Minister. So let's keep working together. Let's make sure that we're doing this in a nonpartisan way that's true to the true spirit of Jordan's memory. I believe that we can do that. I do believe that we can get back there. And I'm very, very encouraged that the family is here and continuing to be constructive in their work that they're doing with regards to legislation. So thank you for the time, Honorable Chair.
Thank you, Honorable Mr. Wiebe. Is the committee ready for the question? So the question before the committee is as follows, moved by Mr. Balkan, that the amendment to Clause 7.3 of the bill be amended by striking out everything dispensed. Shall the sub-amendments pass?
No.
Yes.
I hear a no. All those in favor of the sub-amendments, please say aye. All those opposed, please say nay.
Nay.
In my opinion, the nays have it, and the amendment is accordingly defeated. Mr. Balkan?
A recorded vote.
Recorded vote has been called. As a recorded vote has been requested, all those in favor, please raise their hands.
1, 2.
Looked like 3 to me.
All those opposed, please raise their hands.
1, 2, 3.
The amendment is accordingly defeated.
Oh, sorry, I have to do one more thing. Nays 2, oh, sorry, nays 3, ayes 2.
The amendment is accordingly defeated. Now we'll move back to debates on the amendments moved by Honorable Mr. Wiebe.
I can get rid of some things for you.
The floor is open for debates on the amendment brought forward by Honorable Mr. Wiebe. Anybody like to speak to the amendment? Is the committee ready for the question?
Question.
Here we go.
The question before the committee is as follows, that Clause 7.3 of the bill, moved by Honorable Mr. Wiebe, that Clause 7.3 of the bill be amended, dispensed. Shall the amendment pass?
Pass.
I hear a no.
Here.
All those in favor, say aye.
Aye.
All those opposed, please say nay. In my opinion, the ayes have it. The amendment is accordingly passed. Shall Clause 7 pass as amended?
Pass.
Clause 7 is accordingly passed.
As amended.
Clause 7 is accordingly passed as amended. Shall Clause 8 pass?
No.
I hear a no. It has been moved by the Honorable Mr. Wiebe that Clause 8 of the bill be amended in the proposed subsection 264.
I read that.
He has to move
Yeah.
it
Ha.
first.
Yes.
You're recognized.
Honorable Mr. Wiebe.
You read my mind, Honorable Chair. I move that Clause 8 of the bill be amended in the proposed subsection 264.1 brackets 2 by adding unrelated after 2.
It has been moved by Honorable Mr. Wiebe that Clause 8 of the bill be amended in the proposed subsection 264.1 subsection 2 by adding unrelated after 2. The amendment is in order. The floor is open for debates. Honorable Mr. Wiebe.
Once again, for clarification of the for the committee, there was a drafting error with Bill 5. The wording of both of these sections is ambiguous, so it should be referring to two separate incidents. These amendments establish internal consistency within the Act.
Thank you, Honorable Mr. Wiebe. Would anybody else like to speak to the amendments? Seeing none. Is the committee ready for the question? The question before the committee is as follows. Moved by the Honorable Mr. Wiebe that Clause 8 of the bill be amended in the proposed subsection 264.1, subsection 2 by adding unrelated after 2. Shall the amendment pass?
Pass.
The amendment is accordingly passed.
As amended in there.
Shall Clause 8 pass as amended?
Pass.
Clause 8 as amended is accordingly passed. Shall Clause 9 pass?
Pass.
Clause 9 is accordingly passed. Shall Clause 10 through 13 pass?
Pass.
Clauses 10 through 13 are accordingly passed. Shall the enacting clause pass?
Pass.
The enacting clause is accordingly passed. Shall the title pass?
Pass.
The title is accordingly passed. Shall the bill be, as amended, be reported?
Agreed.
Agreed. The bill shall be reported as amended. Order, please. I would like to inform the committee that under our Rule 84-2, the following membership substitution has been made for this committee, effective immediately. Honorable Minister Sandhu for Honorable Minister Wiebe. Thank you. Does the minister responsible for Bill 31 have an opening statement?
Yes, I do.
Honorable Minister Sandhu.
Thank you, Honorable Chair. I appreciate the opportunity to welcome everyone here this evening. It is my pleasure to be here on behalf of my department as the Minister of Public Service Delivery. I appreciate all the members who joined us this evening to discuss the important legislation, Bill 31, the Property Control for Grocery Stores and Supermarkets Act, various act amended. This will amend the Law of Property Act, the Real Property Act, and the Municipal Board Act to stop the use of property control in the ownership and leasing agreement in the grocery sector. So more locations are available for grocery stores and supermarkets to sell fresh food and groceries. Large grocery chains use property control like restrictive covenant and exclusivity clauses to limit access to the real estate that new grocery need to enter the market. Our government promised to eliminate the restrictive covenant that drives up grocery prices. By prohibiting new property control and avoiding or amending existing property control, we will increase the competition, which will help increase competition, will help grocery prices in check. This will amend 3 separate acts to help increase competition by allowing more grocery stores and supermarkets to set up shops in Manitoba. Under amendment to the Law Property Act and the Real Property Act, certain property control can no longer be created and new ones are voided. Existing property controls are voided unless the holder makes a registration under the Real Property Act within 6 months after the amendments came into force. Individual may initiate the review of the property control. The matter may be referred to the municipal board if the minister considers the property control to be contrary to the public interest. The municipal board will decide on whether the property control should be voided. More competition in the grocery industry is expected to increase access to food for sale and make more affordable for Manitobans. Thank you, Honorable Chair.
Thank you, Honorable Minister Sandhu. Does the critic from the official opposition have an opening statement? Mr. Ginter.
Thank you, Mr. Chair, and I appreciate the opportunity just to put a few words on the record and thank the minister for bringing the bill forward and his staff as well here today for their work on this legislation. In principle, I think we support it. We support greater competition among grocers. I would note, I'm not optimistic that that this bill will, reduce grocery prices, at least in the immediate term. It applies to grocery stores that are 2,000 square feet or larger. I don't know if there are any real-life examples in the province of that this legislation would directly affect. So, in principle, we support it, but yeah, with those reservations. Thank you.
Thank you, Mr. Ginter. During the consideration of a bill, the enacting clause and the title are postponed until all other clauses have been considered in their proper order. Also, if there is agreement from the committee, the chair will call clauses in blocks that conform to pages with the understanding that we will stop at any particular clause or clauses where members may have comments, questions, or amendments to propose. Is that agreed? Agreed. Shall clauses 1 and 2 pass?
Pass.
Clauses 1 and 2 are accordingly passed. Shall clauses 3 through 5 pass?
Pass.
Clauses 3 through 5 are accordingly passed. Shall clauses 6 and 7 pass?
Pass.
Clauses 6 and 7 are accordingly passed. Shall clause 8 pass?
Pass.
Clause 8 is accordingly passed. Shall clause 9 pass?
Pass.
Clause 9 is accordingly passed. Shall the enacting clause pass?
Pass.
The enacting clause is accordingly passed. Shall the title pass?
Pass.
The title is accordingly passed. Shall the bill be reported?
Agreed.
Agreed. The bill shall be reported. On to Bill 42. Does the minister responsible for Bill 42 have an opening statement?
Yes, I do.
Honorable Minister Sandhu.
Thank you, Honorable Chair. I appreciate the opportunity to welcome everyone here this evening. It is my pleasure to be here on behalf of my department as the Minister of Public Service Delivery. I think this is a time well spent for our government to have an opportunity to talk about this important bill, the Bill 42, the Buy Canadian Act. Our government has always stood up for Manitobans, and we will continue to do so even in challenging times. In light of the current economic challenges posed by the U.S. administration, our government is standing up for Manitobans, standing up for Canadians. This will signal our government's commitment to prioritize goods and services that are made in Canada. It directs the government to establish a Buy Canadian policy. This policy will outline steps government will take to stand up for Manitoban jobs and our local economy. It establishes a framework to prioritize the procurement of Canadian-made goods and services. We know that in these challenging times, we must all work together to support our local economy. Our government is committed to standing up for Manitobans and changing our practice in order to protect the jobs of Manitobans and Canadians. In response to the U.S. tariff, we are bringing forward this legislation to support Canadian suppliers. As mentioned in our budget 2025, our new Buy Canada policy will make sure government contracts support Manitoba and Canadian businesses and workers. This will not only help us create more jobs, but also keep our economy Trump-proof. By supporting Canadian-made goods, the bill aimed to contribute to the overall growth of the Canadians and the Manitoba economy. Thank you, Honorable Chair.
Thank you, Honorable Minister Sandhu. Does the critic from the official opposition have an opening statement? Mr. Ginter.
Thank you, Mr. Chair, and again, appreciate the opportunity to be here and just put a few words on this bill. Again, thank the minister and his staff, everyone involved in developing this legislation. You know, it's always a good thing to buy Canadian, especially these days. I would note in the minister's remarks that he talked about Trump-proofing the economy. I would also want to bring to his attention or remind him as well that you know, Manitobans, Canadians are facing tariffs from other countries as well. So that's just something that we got to keep in mind as well. But in principle, it's a good initiative. You know, I was just hopeful in debate in the chamber that we could get an idea of what the financial impact would be on the province in terms of provincial government procurement, and also what the timelines would be, how long the minister anticipates the development of the regulation to take, and some other questions that we had. So unfortunately, it's in that respect, there's not a whole lot of detail. But again, we in principle support it, and so with those few words, I'll close my remarks.
Thank you, Mr. Ginter. During the consideration of a bill, the enacting clause and the title are postponed until all other clauses have been considered in their proper order. Shall Clause 1 pass? Pass. Clause 1 is accordingly passed. Shall Clause 2 pass? Pass. Clause 2 is accordingly passed. Shall Clause 3 pass? Pass. Clause 3 is accordingly passed. Shall Clause 4 pass? Pass. Clause 4 is accordingly passed. Shall the enacting clause pass? Pass. The enacting clause is accordingly passed. Shall the title pass? Pass. The title is accordingly passed. Shall the bill be reported? Agreed. The bill shall be reported. The hour being 8:38. What is the will of the committee?
Committee rise.
Committee rise.
We did it.
The gavel.
That was good.
Finishes it. Yeah.